All right, this video was a lot more work than I expected. You'll notice I'm in a different suit because it spilled over to different days. Anyway, Long Island Audits, and Sean Reyes, the case was dismissed, a defamation case. It looks like it was dismissed procedurally for lack of standing. That's the arguments that were advanced. I looked at the docket, I pulled the pleadings, and I reviewed them. And they're saying that, hey, you know what? This is really a defamation case that should have been brought. I hate that word should, it's a worthless word. Should have been brought in the name of Long Island Audits, Inc., not Sean Reyes individually. And one of their main weapons that they used, if you want to call it that, was the sign-in sheets, which I have copies of, and I'll show them to you. True, Long Island Audits signed in when it appeared at the hearings. But that doesn't stop an individual from being defamed who represents the entity. Under California's agent immunity rule, corporations cannot act except through their agents. So you could very well appear on behalf of your corporation and be defamed personally based on the statements that are later made about you. Now, statements made in legislative proceedings, at least here in California, and again, I'm a California attorney. This is not legal advice. I'm just commenting on a public issue. Can't rely on this information. I'm just giving you my perspective. The stuff that's taken care of, statements made in public hearings, stuff, those are all privileged. What matters is what happens outside of the hearing. And this mayor, who has a Facebook page and 13,000 followers, posted comments to it. And they're not denying one of the elements, which is publication. The judge is saying that his and him really meant the company. Now, when you look at defamation, you look at things in terms of the ordinary plain meaning that would be interpreted not by lawyers, but by the public at large. The motions to dismiss they brought were very roughly akin to 12b6 motions. They also hit them with what would be in California a CCP 128.7 motion, which is a sanctions motion for bringing a frivolous pleading. I didn't hear anything about what attorney's fees were awarded as part of that hearing because that was also on the docket as well. And did the judge make a ruling on that? I really don't know. The problems I'm having with this is him and his is inconsistent with a company. And when I read the post by the mayor, it was very consistent with an individual. Now, yes, they didn't say him by name, but then again, that's exactly what happened in the Amber Turd trial. When she wrote her op-ed in the Washington Post, she never mentioned Johnny Depp by name, but everybody knew who he was referring to. And the question then becomes, when the mayor posts to a Facebook with 13,000 followers, none of them knew that this was, Sean Reyes or Long Island Audits, nobody. Another question to be determined. Now, Sean said he's going to appeal, and his lawyer will need to look into that. But it looks like what the judge is really saying is if you want to bring your defamation case in the name of Long Island Audits, go ahead. And I would be wary if it were me, this is my own perspective, of appealing that decision because it's a lot quicker to simply file the defamation case rather than potentially blow a statute of limitations deadline, especially if you get an adverse ruling, because the record isn't well developed, for example, and, whatever he wants to do on appeal, it sounds like the shortcut route is to simply refile, but this time in the name of LIA Inc. And on top of that, hold the mayor to the admissions that were made in his pleadings, including the request for an evidentiary hearing when they said that those statements were about LIA Inc. Here are my comments, just me thinking out loud. Defendant published a written statement on his official Mayor Paul Sidley Affrey Facebook page. This is going to be changed in the amended complaint. So we have to be careful about inconsistent allegations. And the defendant wrote, the harassment and death threats from him and his followers are unacceptable and will not be tolerated. Well, Sean, I'll just say Sean at the same time. He says, hey, him is about me. And I would agree with that. But he's saying, if I heard him right, the judge is saying him refers to a company. I don't write like that. I don't say that. I say the company. And they're distinct legal entities, the person as an individual, as long as it's not something that is, an alter ego of the company where there's such a blurring of the lines that it's one is really the extension of the other, they lose that corporate immunity. All right, so we're gonna see in a motion to dismiss brought by this attorney against Sean that he said him referred to the company Long Island Audits Inc. Now, one of the things that Sean said is, I don't get it. Well, this is, first of all, I'll give him major props for subpoenaing people and putting them on the stand. I'd love to watch that. In the motion to dismiss, paragraph 6, the mayor states him is about Long Island Audits, not SPR, Sean Reyes. That's the source of Sean's confusion. The sign-in sheets, when he went to that meeting, the city council meeting, or I think it was city council, he signed in as Long Island Audits. So now they were using that as a party admission against him. Now he can drive a straight line from point A to point B, and the him is the company. Here it says the statement doesn't mention Long Island Audits or Sean, pinning it down as the mayor admits to Long Island. Would the public know this is about Long Island Audit? Certainly. So one of the things about a publication is how far did it reach? This guy's got, I think, 13,000 subscribers. So anything he posts would hit his subscribers. And in my neck of the woods, that would definitely meet the publication. And in fact, his attorney admits that publication element of, I think it's 5 elements you have to prove. That one has already been established. You got to get the others. There's no winning when you're close. You got to get them all. Okay. And I'm looking at what this, the complaint, and I'm just trying to make notes here. He mentioned 83610 is a serious criminal act. It is, but my read of the statute very quickly was that it only pertained to written threats, and Sean didn't make any written threats, so that would not be the right statute. But still, the idea is, if at least in California, if you're accused of a criminal act, that would be defamation per se, defamation on its face, where damages are already attached and presumed. And we have a very unusual, strange way of calculating those damages. I did when I won my trial in a defamation case, where it's really using Zsa Zsa Gabor as the reasoned logic as to how much it should be. Okay. Some of these are all conclusory. Defendant published false statements, and the mayor, through his lawyer, admits it was published. Here is his defamatory per se as they imputed serious criminal conduct, sending death threats. This is incorrect as a defamation per se in California if restricted by stated statute. Better just to leave it out. Again, not the best English. I'm just saying sometimes it's better not to say specifically the statute other than to say that it violated statutes or was on its face, defamatory, and then the reasons so that it's not conclusory. There was, but still, this is the Sanwa case in California. The same rule applies that I saw in Florida, where exhibits attached to a complaint will override conflicting allegations. And here it says Melbourne Mayor Paul Alfrey. Unfortunately, the YouTuber is getting his information from the person who brought him here and in my personal business dispute. She's not being honest with him and has a history of prior false reports, including falsely reporting a truck stolen, abandoning her dog at our Brevard County animal shelter. I want to be clear, his free speech was not denied and our meeting rules were followed and enforced fairly. Now, statements made at an official proceeding under 425.16 of the CCP here, section E, 100% privileged. Now, they can say what they want and you can't sue them over that. It's what they do outside of that privilege that gives it its teeth, okay? So here it says the harassment and death threats from him and his followers. I'm reading that as an individual. That is a plain statement to me. The mayor is saying, I didn't say it was him. I didn't say who it was. But at the same time, when you have 13,000 followers on Facebook, anything you write is going out to a very large audience. More than likely, they would then ask about it. It would get circulated around people who know, and then they would find out that it leads back to Sean anyway. So not a good argument. And it says, as many people may be aware from social media. So here he's acknowledging it's been published and it's gotten out of there. Not a good statement for this judge. I mean, this mayor, very much in favor of Sean for how it's written. These are, again, party admissions. As many people may be aware, that's kind of a strange, if it's many, then how are they, who makes a living by claiming his First Amendment rights were violated, blah, 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 blah. Huber claims he was removed. Do not address the mayor account individually. I know that Sean didn't know what to do. He's not a lawyer. But if I'm faced with a motion to dismiss, I would have just asked for permission to amend the complaint so that we have an additional plaintiff, which would be Long Island Audits. Then they would say, well, that's a corporation. You can't represent a corporation because you're not a lawyer. True. And then, Judge, give me time to hire an attorney who can represent me, represent my company. And then we don't have to circle back and replay this thing all over again. Again, this is what I call just the writing I hate. Defendant, defendant. Why say defendant and then say defendant in quotations? But you know what? Some lawyers are just locked in this way, okay? Now, he says, this is the Sanwa decision. There's also the Meade case as well. Things that are attached to the complaint take precedence over conflicting allegation. And Exhibit A to the complaint was attached. This kind of misleads you into thinking it wasn't. It was attached. And then here, plaintiff is wrongfully claiming standing in this cause of action as an individual, despite being at city council meeting in their capacity as Long Island Audit. Notice that it says there. Doesn't say his, doesn't say him. Pay attention to that. And the sign-in sheets did say LIA on all of them. Okay. The other thing that was kind of a iffy thing for Sean is when you're going to speak in front of the council, there's a requirement that you are authorized, in so many words, to have some kind of standing or some say in the local rules that are being adopted or the regulations being adopted because you live there. He didn't, but whatever. He still got to speak. Corporation cannot represent itself. That's true in California. Foreign corporation transacting may not prosecute. We have the same thing under the Corporations Code. They're now saying the Facebook is the defendant's official mayoral account to give some kind of gloss that there's immunity here because it's part of an official proceeding. There's no proof of that. Now, remember, there's a big difference between what a lawyer says and what is evidence, and what he says is not evidence. I just call it self-serving BS. Okay. Defendant has absolute immunity for statements made while carrying out his mayoral duties. Generally true, but the Facebook, that's after the meeting was over. That's him posting to his own, I think, private account. The post on Facebook dealt also with personal matters. And then we have DeCastro here. So hi, Chili. I didn't know he was involved in Florida, but hey, good for him. The mayor's lawyer here is saying that buying through these videos and the self-created viralness of the matter, plaintiffs gain followers and notoriety for attacking the mayor in any way possible and attempting to bully the mayor into resigning. Well, you need to be aware, at least in California, the Sam Yorty decision, other cases, he was the guy running for mayor at the time, or he was mayor and running for re-election. If you say unkind things, they basically say grow thicker skin, because when you run for political office, you must be ready for and accept scathing criticism. And so bullying the mayor into resigning, well, everyone, me, you, all of us have rights to criticize heavily our politicians, and you got to grow thicker skin. The only limit, there are a few, one of the main ones is you can't say that he suffers from mental illness. That is a no-no. Plaintiff has not lost viewers or followers. This is exactly what plaintiff does in all their interactions. Notice that there's a different pronoun here. Okay. I think the lawyer is trying to keep this in the realm of not Sean personally, but in Long Island Audits, Inc., and therefore using their. So, plaintiff's actions against public officials are exactly what his current followers expect from him, as well as what attracts new followers. Well, the same could be said about other organizations that are out there, whether it's the National Enquirer or whatever. I mean, they're there to attract viewers, so what? And there's no foundation for this. This is supposed to be an evidentiary matter. Therefore, where's the declaration? Was it testified to on the stand under oath? Otherwise, these are legal arguments or lawyer arguments. They're not evidence. Think of Carly Simon's Killing Me Softly with his words, and I'll give you bonus points if you cite that in any brief. The Jews for Jesus case, I took a look at it, is about false light. Florida does not want to recognize a false light claim. Same in California. It's not recognized, I should say, when it's pled in conjunction with defamation because it's considered a superfluous claim. I love it when lawyers sue for defamation and they include false light. I automatically know my anti-SLAPP is going to win. Next is, well, the other thing about defamation by implication, it could even include true statements that, if taken out of context or presented in a misleading fashion, creates a false impression to someone. So this is the instance where you can actually defame somebody by saying true things, but if you say it in a way where you omit facts or, leave the meaning so that it is harmful, yeah, it could be defamation too. These are all conclusory statements. And where's the declaration establishing any evidence for this? He says, again, the defendant's official mayor Facebook page. I looked at the Facebook page of the mayor, 13,000 followers. Facebook's a public forum. Obviously, they had to admit that there was a publication. Anything the mayor puts out on the Facebook page is going to be read by a lot of people. It's open source and therefore a public forum, quite no question. On top of that, the argument is, well, we didn't really say anything about him. Well, that's exactly what happened in the Amber Heard trial. I mean, her op-ed in the Washington Post did not say Johnny Depp by name, but everybody knew that the things that she claimed to have suffered from, she's attributing to him. So it's comical to even make that argument. Shit. The inability for defendant to properly understand what they have been accused of denies defendant adequate notice to prepare an effective defense. Total bullshit. If you didn't understand the case, you would not be filing a motion to dismiss claiming that there's a lack of standing. You would not be saying that the Facebook post itself doesn't reach the levels of defamation. You would not be able to say that the elements have not been sufficiently pled. Double negative. Sorry, you get it. And then here, motion must be dismissed with prejudice rather than alternatives available to the court. You know, I don't care what states you're in, there's a great proclivity to having the matters heard on the merits rather than procedural dismissals. This would be a procedural dismissal. You didn't name the right plaintiff. You don't have the right, you're not in the right court, whatever. Okay. Why the judge didn't allow him to amend the complaint to add Long Island Audits, Inc. as the other plaintiff? Well, that certainly would be very beneficial. Ambiguous. To meet that standard, it has to be so unintelligible that you cannot even figure out what it is they're saying. So then there was an amended complaint filed, same two causes of action. And here it says, defendant acted personally in his individual capacity, publishing the statements described in and is used solely in his individual capacity, sued solely. And then here it says, bearing the title Melbourne Mayor Paul Affrey, is not an official City of Melbourne government page, is not owned and administered by the city. Previously in the complaint, he said that it was. Written statement on his official, a government associated platform used to communicate. So this is a big change right here. Still, whatever. And I don't want to go through all the rest of it, but there's the two counts. And here was a motion for evidentiary hearing, and they wanted to basically set aside 8 hours, which is mind-boggling to me. And this, once again, repeats what we've already been talking about. Does not appear plaintiff has brought the action of the proper plaintiff. It should be Long Island Audit, Inc. So why couldn't he amended to be allowed to amend? Maybe he never asked. And then this is important here. Looking at the first factor, that the statements made by defendant are directed at the organization Long Island Audit and the common practice through its social media, not his, and addresses the alleged censorship as claimed on the Long Island Audit social media pages. Notice that this lawyer never uses his or him. It's it and they. So I'm having problems with the way this judge is saying things. It's just an see, when you interpret statutes, you interpret them according to their plain and ordinary meaning, and then from there you decide whether or not it needs further work. So here, this is a judicial admission that the mayor was only addressing Long Island Audit, Inc. And neither plaintiff Sean Paul nor Long Island are named directly, nor are there any pictures or logos. Again, I've already covered that. The Amber Heard case is an example. It doesn't have to specifically say somebody for you to know that they're talking about somebody. Okay. And then he called this a shotgun pleading. No, I don't think it's a shotgun pleading. I've dealt with one. One of them I just filed a demur to was 624 pages of just generic bullshit. It's like missing persons. You know, when you get to the end of the page and you don't know what you just read, that's not a shot. Sean did not file a shotgun pleading. It was two claims. It wasn't more than 10 pages, and it was identifying specific statements that he said defamed him. So, nope, wrong, wrong, wrong. None of plaintiff's social media is in plaintiff's individual name. Where's the evidence of that? That's just an argument. Evidentiary hearing for determination of plaintiff's standing in respect to defendant. Okay. An applicant, representative, or person who has legal standing to support or oppose a quasi-judicial matter will be permitted enough time as reasonably determined by the city council to create a record before the city council. These matters generally include site plan, zoning of property, conditional use. So these are all real property issues. And it was Long Island Audit. And then he came back to another hearing, open argument, Long Island, open comment, I think, Long Island Audit. And then mayor's corruption, that made me laugh. All privileged, Long Island Audit. So they used this to say it was the company. It wasn't Sean. I still have trouble with the pronoun thing here. Now, this is very high level legal bullying. I've done it very effectively. In California, it's called a 128.7 motion. It's just you send it to them, and then there's a safe harbor period. If they either dismiss the action, then you will not file this motion, put it in front of the judge, and get personal monetary sanctions against the lawyer. So that's what this was all about. They do a safe harbor, and then they file it. Motion to determine standing, which sounds like it went against him. Motion to dismiss plaintiff's amended complaint. That went against him. Defendant's motion for sanctions. I didn't hear Sean talk about that, and there's nothing posted to the docket as to what happened there, but they would have been seeking attorney's fees. I think that's the reason why Sean's confused about this, because the judge is saying that it's him, but him, according to this judicial, what I would deem a judicial admission, refers to the company. And even though I would not use the terms that way, that's what they're saying. And also the big question is did he preserve for appeal the ability to amend his complaint? Did he seek the ability to amend and the judge simply shot it down? Or did the judge really just say, look, as far as I'm concerned, there's no case here. It's dismissed with prejudice and can't file it again, but you can come back and file for the company if you wish. And then the ultimate joke would be they then say on the defense side, you know what? I don't understand why you're bringing this in the name of the company, because him and his clearly meant Sean Reyes. And I would say this was an admission made by a agent for a party, and therefore it's still binding, because otherwise they're taking inconsistent positions to get out of liability, and no one likes that.